Welcome to the 140th Wing Privacy Act training. This training fulfills the annual training requirement for Privacy Act as required by AFI 33-33-2. Whether collecting taxes, adjudicating a security clearance, or issuing benefits, there are countless reasons why the United States government might collect and use an individual's personally identifiable information, or PII. But this personal information is sensitive, and in the wrong hands, it could put individuals at risk. The government must take care to protect PII and the individuals to whom it belongs. If you work with PII, you need to protect it. And if you fail to do so, you or your organization could be subject to civil and criminal penalties. This course includes what is the Privacy Act and its purpose, answers what is PII, what the training requirements are, and then reviews both organizational and individual PII responsibilities, including what to do if there is a data breach. After this course is complete, you will be able to identify personally identifiable information, or PII, understand why it must be protected, recognize the policy and procedures related to the use and disclosure of PII, and identify the organization's and individuals' responsibilities for safeguarding PII. The federal government's legal responsibility for safeguarding PII stems from the Privacy Act of 1974. The Privacy Act calls for the establishment of rules of conduct and safeguards for PII held by the federal government. It requires that the government maintain accurate, applicable, timely, and complete information. The second item noted on this slide is a systems of records, which is any information system that stores PII and from which PII is retrieved via the individual's name or other unique identifier. If an organization determines that it must collect and maintain PII and that PII will be retrieved by a personal identifier, then the organization must publish a Systems of Records Notice, or SORN, in the Federal Register. A SORN notifies the public that an agency will collect and retrieve PII in a Systems of Records. It must be published in the Federal Register before any data collection can begin. SORNs include the legal authority to collect the PII, the type of PII that will be collected, the safeguards in place to protect the data in the system, how individuals can determine if they are part of that system, and how they can obtain a copy of their record if they are part of that system. So, what is PII? We all use PII to identify ourselves. PII includes information like a driver's license number, an address, or a birth date. Social security numbers and biometric records such as fingerprints are also examples of PII. PII includes any information that can be used to distinguish or trace your identity, either alone or when combined with other information that is unique to you. This includes the DoD ID number, which falls into this category because it is a unique personal identifier and can be used to retrieve records about an individual. Guess what? Everyone, military, civilians, and contractors are required to take this annual training. As per AFI 33-33-2, privacy awareness training is required for all federal employees, which focuses on the individual's roles and responsibilities of the Privacy Act and safeguarding PII. In addition, if you are identified as a privacy manager, a systems manager, a local systems manager, or work in a legal office, there are additional training and responsibilities found within the AFI. If anyone falls under one of these categories and requires additional information, please reach out to my office. Look at the second bullet on this slide. The term Controlled Unclassified Information, or CUI, has replaced for Official Use Only, also known as FOUO. Now, let's go back up to the first bullet and review the PII collection and handling guidelines. The federal government collects and maintains PII in order to carry out its critical functions. For example, the government may use PII to track Social Security payments and collect taxes. But to carry out these key functions, the government's information must be applicable, accurate, timely, and complete. The government must also safeguard PII and limit access to it. Only those individuals with a need to know, that is, individuals with official authorized access to the information, may access and use a record or systems of records containing PII. So, only collect information that you are legally allowed to collect, and then absolutely only what you need to perform your business function. Place CUI first in the subject title of the document that contains PII. Lock your PC when away from your workstation by pulling your CAC from the reader. Follow procedures for deleting and shredding documents containing PII when no longer needed. Report suspected privacy violations or incidents. Use CUI labels when protecting CDs, tapes, or other documents and folders. Those new labels are SF902. Use a CUI cover sheet when PII documents are out where they can be seen. This new cover sheet is SF901. Let's talk about PII restrictions. Do not place PII on any shared drive without the proper security permission groups applied. Only those with a need to know need to have access to this information. Do not email sensitive PII unless the information is encrypted and the email is properly formatted. Do not email PII to a distribution list. Do not email sensitive PII to any civilian email address outside of the .mil domain. This includes your own civilian email. Do not distribute or release PII to other employees unless they have a need to know. Do not leave sensitive PII in a voicemail. Do not store PII on desktops or laptops. Do not forget, protecting PII is everybody's responsibility. Now, when you're emailing PII, guess what? Email still has the old FOUO, not the new term CUI. Eventually, everything will catch up. In the meantime, remember to use the FOUO button if any PII is in the email. This will place the appropriate statement and encrypt your email. For the transporting of PII, if you are using ground mail, use brown or white envelopes to mail your documents. Never use the messenger type envelopes. You may double wrap the documents using an inner and outer envelope if you deem it appropriate. Be sure to mark the outer envelope to the attention of the authorized recipient. Never indicate on the outer envelope that the contents contain Privacy Act protected data. When hand-carrying PII documents, never leave them unattended, and ensure that the contents are properly covered using the CUI cover sheet and/or placed in an envelope to shield the contents. Do not leave PII documents on a person's desk. Hand them to the recipient to ensure that there is no unauthorized access. Now, let's discuss the storing of PII. During duty hours, when those personnel not authorized PII access enter the workspace, cover or place documents in an out-of-sight location with a CUI cover sheet on top. Use filtering devices on computer screens to blacken the view. Lock your computer when leaving, even for a brief moment. After duty hours, place records in a locked or unlocked drawer or cabinet at the end of the day. However, special categories of Privacy Act protected data should be placed in a locked receptacle. So what are those special categories? They include investigative files, personnel files, security clearance files, adverse action files, and any category that, if released, would embarrass or harm the subject. Now that you have all of this PII, how do you dispose of it? Can you just throw it away? If anyone says yes, then you have failed this block of instruction and will be forced to take the computer-based training version of this class, which is more than enough punishment. So don't assume that documents containing PII that are placed in a recycle bin are being shredded prior to being recycled. Only place them in the authorized and designated locked shred bins. Those are the big blue locked bins that you find in the offices here at the 140th Wing installation. Dispose of PII in a manner that does not result in a privacy breach and prevents inadvertent compromise. A disposal method is considered adequate if it renders the information unrecognizable or beyond reconstruction. Disposal methods may include tearing, burning, melting, chemical decomposition, pulping, pulverizing, shredding with a GSA-approved shredder, and mutilation. The 140th Wing does have a recycling contract. Protecting passwords and personal information. This is good advice for all of your passwords. Ensure you safeguard your passwords not only at work, but also at home. At work, you can place your passwords in your Outlook Notes section. Only you can access this information with your CAC. With this in mind, do not give out your CAC and PIN to anyone. This also includes SIPR tokens. All CACs and SIPR tokens must be secured at all times. If you decide not to follow any of the information in this block of instruction, then here are some penalties for an unlawful release of PII. Any potential or actual breaches must be reported to the Unit Privacy Manager by anyone discovering it. Failure by military members to obey the mandatory provision in AFI 33-33-2 is a violation of Article 92.1 of the UCMJ. Civilians who violate the information security policy may be disciplined in accordance with AFI 36-704, Discipline and Adverse Actions of Civilian Employees. The senior level individual who is in the chain of command will appoint an investigating official for the organization where the actual or possible loss, theft, or compromise of the information occurred to conduct an inquiry of the incident to determine if it is an actual breach, the cause, and if there was any criminal intent that would warrant a criminal investigation. If you knowingly and willfully disclose Privacy Act protected data to any person not entitled to access, then you may face a misdemeanor criminal charge and a fine up to $5,000 per incident. If you are maintaining a systems of records without meeting the public notice requirement, then you may face a misdemeanor criminal charge and a fine up to $5,000. To recap, PII is information that either by itself or when combined with other information is linked solely to an individual. If someone tampers with or steals this information, it can have grave consequences for the individuals whose PII was disclosed. Individuals with stolen PII are susceptible to identity theft. Social security numbers and birth dates could help a thief apply for credit cards in someone else's name or commit other criminal acts under that identity. Losing PII can damage a person's reputation. It can also cause embarrassment and great inconvenience. Because of the extreme consequences associated with the loss or misuse of PII, the federal government is required by law to safeguard its collections of PII. A federal agency that loses or misuses PII will lose the trust of the public and the agency's members. It may incur significant legal liability. Consequences may also include expensive remediation. The organization may need to provide credit monitoring services to the individuals affected by the lost or misused PII. For example, the DoD share of the Office of Personnel Management, or OPM, data breach back in 2015 was reported to have exceeded $132 million. So what happens if you have a breach or discover a breach? First, immediately notify your supervisor. Then your local Unit Privacy Act manager, usually within your CSS, needs to be notified. The Privacy Act manager, which is myself, will be notified. The wing commander will be notified, and any other appropriate official of the occurrence. The individual responsible for the breach will have their network access locked. That account will stay locked until the Cyber Awareness and the Privacy Act CBT is accomplished and a letter is signed by the individual's commander. All PII breach procedures and forms can be located on the 140th Knowledge Management SharePoint site. Here are some resources for you to use, and this now concludes this block of instruction. If you have any questions, please feel free to send me an email. Thank you.